Good morning, and welcome to the Hillsborough County Board of County Commissioners Land Use Meeting. Will everyone please rise for pledge and invocation given by Chaplain Commissioner Stacy White.
Thank you, Mr. Chairman. We'll begin with the Pledge of Allegiance. Attention, salute, pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Heavenly Father, you have given us many finite resources, one of which is the land on this earth. So I just pray that you will guide this board, our staff, and stakeholders as we make important decisions on how to best put that resource to use. Lord, I, as always, pray for our first responders and members of our armed forces, especially during this special time of year when many of them have no choice but to be away from their family and friends and loved ones. So I pray for special blessings for them at this time of year. I ask for this guidance and for all of these blessings in your heavenly name. Amen.
Thank you, Commissioner White. Mr. Beretta, any changes to the agenda?
Joe Morrell, Development Services staff. Yes, sir, we do have some changes to the agenda. Commissioners, we've had a couple items that were sent to your offices yesterday that didn't travel with the agenda. One of them was an interlocal agreement, and another one was a commissioner item. They should be before you in front of your area on the dais. And then we do have several changes to the agenda that I will read into the record at this time. The first one is found as item A1. This is rezoning 18-0568. This application has been withdrawn by the applicant. A2, rezoning PD 18-0996. This application is being continued to the February 12th Board of Commissioners meeting starting at 9 a.m. Item A3, personal appearance 18-1154. This application is being continued to the February 12th Board of Commissioners meeting starting at 9 a.m. Item A4, personal appearance 18-1236. This application is out of order and being continued to the January 15th Board of Commissioners meeting starting at 9 a.m. Item A5, personal appearance 18-1355. This application is out of order being continued to January 15th starting at 9 a.m. I think I've made it clear that all the board meetings are starting at 9 a.m. So the rest of the changes will also be sent to a board meeting starting at 9 a.m. Item A6, personal appearance 19-0051. This application is out of order being continued to January 15th. Item A7, personal appearance 19-0059. This application is out of order being continued to January 15th. Item A8, personal appearance 19-0066. This application is out of order being continued to January 15th. Item A9, vacating petition 18-0015. This petition has been continued to February 12th Board of Commissioners meeting. Item A10, excuse me, vacating petition 18-0020. This petition has been continued to February 12th Board of Commissioners meeting. Item A11, vacating petition 18-0023. This petition has been continued to the February 12th Board of Commissioners meeting. Item A12, vacating petition 18-0026. This petition has been continued to the February 12th Board of Commissioners meeting. And finally, item A13, personal appearance 18-1500. This application has been continued to the January 15th Board of Commissioners meeting. That concludes all the changes. Thank you.
Second.
I have a motion by Commissioner Murmer, second by Commissioner White to move the change to the agenda. Let me ask a question. On the two addendums, one being the interlocal agreement, another one being the commissioner items, where will we take those up? At the end of L, or where will we take those up?
At the end of the agenda, sir,
At the end of the agenda, okay.
if that's acceptable.
I'm sorry, the interlocal agreement is a consent item, so that
That's
would
on the
propose to
consent.
be added to the consent agenda.
So
Yes, sir.
the other one we'll take up at the end of the meeting?
Yes, sir.
Okay. My motion by Commissioner Murmer, second by Commissioner White to approve the change to the agenda. Seeing no further discussion, please record your vote. It's not working.
There we go.
Okay.
Motion carried 7-0.
I have a motion to approve consent agenda. Motion by Commissioner Murma, second by Commissioner Kemp to approve the consent agenda. See no further discussion. All those, please record your vote.
Motion carried 7-0.
If you have any B items, your items have been approved. If you have any B items, the items have been approved. For oath, anyone who intends to present testimony, evidence, or to otherwise be heard on any matter scheduled for consideration at today's meeting, please stand and raise your right hand so the clerk may swear you in.
Good morning. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated.
Mr. Moretta.
Thank you. The first item of the agenda is item C1. This is a public hearing for vacating petition 18-0035. Ms. Alicia Alvarez of the Real Estate Department will present this item and be available for questions.
Good morning, everyone.
Good morning.
Good morning, Commissioners. Item C1 today is Vacate 18-0035. This petition...
Ma'am, can you
is-
speak into the mic?
Sure.
Okay.
This petition is by Cesar Gutierrez to vacate a portion of a platted 5-foot utility easement within Lot 72, Block C, within plat of Pinecrest Villa, Addition Number 1, as recorded in Plat Book 14, page 40 of the Public Records of Hillsborough County. The property address is 7523 North Clark Avenue in Tampa. The subject property is located east of North Clark Avenue and north of West Broad Street. The request is made for the purpose of constructing a pool. The petition was routed to appropriate departments and agencies, and there are no objections to this vacation of the utility easement. Staff recommends approval of this petition request.
This is a public hearing. Anyone wishing to speak in favor of the item? Anyone wishing to speak against the item? I have a motion by Commissioner Murma, second by Commissioner Kemp to approve item C. See no further discussion. Please record your vote.
Motion carried 7-0.
Mr. Moretta.
Thank you, Commissioners. Brings us up to the first public hearing for land use. Item E1, this is application number PRS 18-1310. It's located in Ruskin, generally at the southeast quadrant of 14th Avenue Southeast and 15th Street Southeast. This is a project that was zone plan development in 2004. This project permits 345 dwelling units. There is no request to change the entitlements for dwelling units. It has multiple requests that primarily deal with design requirements. And I'll run through those, and as I'm speaking, I'll ask Mr. Israel Monsanto, who's going to run you through some slides that indicate geographically where the changes are occurring. I'll let him make a brief presentation after I give you an overview of this. The applicant is seeking a number of changes. One of them is to modify the location of an amenity center in a park, and also has agreed to conditions that make this particular amenity center and park subject to our gathering spaces requirement land development code. That particular requirement wasn't in place when this property was zone plan development. The current plan development does not have a commitment for acreage. This particular proposal exceeds the acreage requirement that our code would require, and it also organizes those spaces all to occur within a quarter-mile walking distance of all the lots in this proposal. The next modification deals with internal road alignment and also access points. The applicant is eliminating 4 cul-de-sacs. They're creating basically a road system internal to the site that for the most part creates a series of loops and minimizes the use of cul-de-sacs. They've also created 3 additional access points externally. There's also a number of setback changes. The applicant's proposing to reduce the rear yard setbacks from 20 to 15. However, they're maintaining a greater setback in the area north of the site where the site abuts agricultural property right now. They've agreed to a condition that would allow those setbacks to be reduced if rezonings are in the vicinity adjacent to the site prior to the preliminary plat for this project if it's approved. There is a change to that condition that I would note, and there's a change sheet that's been prepared and placed in front of you. The initial condition said that this would occur if the rezoning is approved to allow for similar lots. Staff has worked with the applicant to prepare a more defined metric, which says instead of similar lots, we replace that text with a minimum lot size of 7,000 square feet or less. So accordingly, in that area of the site, which is the northern part of the site, the setback reduction could occur from 20 to 15 feet if those smaller lots are in place when this project goes to preliminary plat approval, if the board approves these zoning changes. I would note also, as part of the internal road alignments, the applicant has also agreed to an additional condition that's not part of your backup. They're committing to a condition that states that all internal project roads shall be public roads. So those roads will not be private roads, and that eliminates potential gating, which was a concern, you know, in the review of these conditions. The applicant is also proposing a change to the front yard setbacks for the 40-foot lot product, which is essentially a 4,000 square foot lot. There's a zoning condition in the original zoning that required that the front facade of the homes have an alternating pattern by 5 feet every other lot. The applicant is proposing a consistent setback. When that condition was imposed back in the original rezoning, then, as there is now, there was concern over the smaller lot products having a narrow width and resulting in a front facade that has a home that's primarily dominated by a garage. So when staff reviewed this, we worked with the applicant. We found it acceptable to reduce the setback to 20 to follow the same front yard setback as the rest of the site, but we did that with the imposition of 2 conditions that they agreed to, and that limits the maximum facade of the front of the building or the front of the residential structure to a maximum of 60% garage, preserving 40% of the facade for you know, front entry feature as may be appropriate when the home is designed. And also, it also aggregates the drives or the driveways for the lots to be adjacent to each other in an alternating pattern. And we feel that those 2 changes in total, as well as the other changes, were acceptable to acceptable level that we could recommend approval of all these changes in total. That with the changes that we talked about. Mr. Monsanto is going to take you through a brief presentation in terms of where these lots are organized and how the road system is oriented that I just spoke to. Thank you, Israel.
Good morning, Commissioners. Israel Monsanto, Development Services. This is a general comparison for both PDs. The one to the left is the existing approved PD plan, and the one to the right is the proposed changes. As you can see, per the legend, you have the site crossed by wetlands in both options, and you have the residential areas in yellow. But generally speaking, the areas for residential uses are being maintained. Some of the differences are that this area here is being reduced for the residential lots, so you have more open space in this case. And also you have an area here in the middle of the wetlands that was actually for optional residential development, and the applicant is not proposing those residentials in the middle of the wetland anymore. The next slide is there are required lots in specific areas of the PD plan, and that is not changing with this PRS. So you have here that these lots adjacent to the west, they have to be 60 feet in width, and this is being maintained here in the proposed PD plan, as well as these 50 wide lots here on the west side of the TICO corridor. They are also being maintained. And these are the location for the 40-foot wide lots, and this is also being maintained in the proposed PD plan. The next slide is, as Mr. Moreta explained it, this is the internal road network. You can see that today the PD has approved 5 cul-de-sacs. The proposed PD plan is removing 4. There is only 1 remaining cul-de-sac here on this location, and you can see also in red new proposed site access that are not contemplated in the existing PD plan. Also, in general, the PD plan has more connectivity. You have more nodes in the proposed PD plans as you had in the current PD plan, you can see that this is a long block going around the site, and this is not the case anymore, so you have more internal connections here. The next PD is the general gathering, community gathering, open space, recreational areas. So you can see there is a proposed park here in this location. The proposed PD is now in this area to the west. You have open spaces and community gathering areas throughout the whole site. The current PD will be subject to the Land Development Code, Section 60218, for community gathering spaces, and there is a requirement of 50 square feet per the number of lots approved. So that will render approximately 0.4 acres if it was developed today. The applicant, on the other hand, is proposing not only to be subject to that requirement, but they are proposing at a minimum 5 acres for the total community gathering spaces. And they're also committing for the park and the amenity center area to be 1.5 acre at least in size. And the last slide, this is the general development standards. To the left, you have the currently approved standards. To the right, you have the proposed. Changes here is the rear yard, as Mr. Morera explained it. They are reducing the rear yards to 15 feet, with exception to the lots adjacent to agriculturally zoned parcels to the north, with the amended condition for the lots that will be developed in those agricultural zones in the future. And the 40-foot lots that are approved today, the staggered front setback is being replaced by a design feature for the driveway's location and also the garage door area in the front facades. Thanks.
Mr. Barrett, anything further?
That concludes our presentation, and we're available if you have any questions. Thank you.
Okay, is the applicant here?
Morning, Mr. Chair. Morning, Board. Happy to see new faces here. Elise Batzel with Phelps Dunbar, 100 South Ashley Drive, Suite 2000, on behalf of the applicant, Eisenhower Property Group. Just to give you a very short background on this property, when we went in to put together a preliminary plat, there were obsolete zoning conditions that needed to be removed. And so while we were in there and started to design, we realized that there were enhanced design features that we could add to the development. And it made sense for us then to come back for a PRS to update the plan and make it more consistent with the guidelines and the code. Joe and Israel did my job for me this morning, and will remain available to answer any questions. Quickly, though, before I conclude, the design features that were added, we wanted to make sure that the development was not a cookie-cutter development. So those design standards that you see added are meant to further that provision in the Ruskin Community Guidelines as well as the comprehensive plan. Second, some of the features enhance pedestrian and vehicular access. You saw the grid-like pattern. Israel mentioned the pocket parks and the community gathering spaces that will total 5 acres and be scattered throughout the entire development instead of just one location, which makes it more pedestrian friendly as well. And finally, again, we updated and clarified those zoning conditions. So I'll remain available for questions. We would ask for your support for this petition this morning. Thank you for your time.
Thank you. This is a public I'm sorry, Commissioner Smith, you want to ask a question now?
After the,
Okay.
sorry.
This is a public hearing. Anyone wishing to address that's a proponent? Anyone wishing to address that's an opponent? Do you waive your time?
Yes.
Okay. Commissioner Smith, you recognize.
Yes, this is not a full rezoning, and so it's not coming completely in compliance with Ruskin Community Plan, but I am happy to see the connectivity. That's the condition that pleases me the most here, is that, and it's the most important, I think, in our community plan, the one that was handed out here, that is adding more roads and adding to the grid system of the transportation in the neighborhood, and then ensuring that that's accessible to the public and that the community will not be gated. That is a huge priority in the Ruskin Community Plan, so I'm really happy to see that, and I'll move approval.
Second.
There's a motion by Commissioner Smith, seconded by Commissioner Merman to approve. Commissioner Merman, you recognize.
I just took my name out of the queue. I think the project is good. It's diversified from other developments that have been developed in the area, larger lot sizes, which I'm very happy about. So I think this is a good project for the area.
Mr. Kemp, you recognized.
Thank you. I was waiting for Commissioner Smith's remarks before I tried. But I just want to say that I'm very happy to see the connectivity, the walkability, the provisions and measures that were made in this, I think, to make it a much better place to live, a much better community.
Okay, we have a motion by Commissioner Smith, second by Commissioner Merman, to approve item E1. Seeing no further discussion, please record your vote.
Motion carried 7-0.
Mr. Moretta.
Thank you, Commissioners. This brings us to item E2 on the agenda, personal appearance 19-0041. The location of this .15 acre parcel is located on the east side of US 301, or east of US 301, on the south of Boyette Road. It's located on the Boyette Road on the inside of a curve. Commissioners, this is a plan development that was approved in 1997. It's basically regulated and developed in two pieces. The pieces on the inside of the curve are pretty much split in half. The existing development on the northern or the northwestern piece is primarily storage. The development on the south side is a veterinarian clinic, and it has some existing accessory kennel as well. The way the land use conditions are organized is on the parcel where the actual veterinarian clinic and kennel reside. Those uses are allowed outright. On the parcel that is sought for proposal, which is the north side, that part organizes the conditions to say that AS1, which are agricultural uses, are allowed, and a kennel and vet clinic is part of the agricultural uses that are allowed. But the condition goes on to say, or business and professional office. So it gives an either or. The development condition that's on the site now that the developer sought when they developed the site was the or to put the business professional office pieces and the uses that go along with that side of it. What they're looking to do is make a text change to be able to pull the kennel out of the other option and allow the kennel to reside at the back part of that parcel in parcel B. Staff has looked at this, and we're recommending approval of it. We feel like it fits in with the PD, and we feel that would be compatible with the development plan. That's what we have to offer in our presentation. If you need more information, we're here and available for questions. Thank you.
Thank you. Is the petitioner present? Yes, sir. Good morning.
Good morning. My name is David Wright of TSP Companies. Our address is P.O. Box 1016, Tampa, Florida 33601, and I've been sworn in. I think Mr. Moreta did a great job of explaining what we're trying to do. I would just like to emphasize that the request applies to only one building in Parcel 2, identified as Pocket B with folio number 0776201.0138 on the general development plan, and the kennel will comply with the conditional use requirements for a kennel per LDC section 6.11.52, and it will be fully enclosed within the building. Again, I'm here to answer any questions you may have. Thank you.
Thank you, sir. This is a public hearing. Is there anyone wishing to speak as a proponent? Anyone wishing to speak as an opponent?
Move approval. Move approval.
There's a motion by Commissioner Merman, second by Commissioner Kemp to approve item E2. See no further discussion. Please record your vote.
Motion carried 7-0.
Mr. Moreta.
Thank you, Commissioners. This brings us to item E3, which is a review of CDD Proposal 19-0105 to establish the Roding Road North Community Development District. Mr. Brian Grady of our staff is going to make a brief presentation. We also have Julie Wisdom available. If there's any questions related to the financial piece, I'll let Brian take it over from here. Thank you.
Good morning, Commissioners. Brian Grady, Hillsborough County Development Services. The request CDD 19105 is a petition to establish the Roding Road North Community Development District. This petition has been submitted by Cassidy Properties Incorporating, requesting to establish the Roding Road North Community Development District. The proposed CDD would encompass plus or minus 102.12 acres generally located on east of Balm River Road, directly north on Roding Road. The application has been reviewed by the County Attorney's Office, Management Budget Department, Public Utilities, Public Works, Transportation Review, Asset Registry, Geomatic Section, and the Development Service Department. No objections to the proposed establishment of the CDD were received. Therefore, staff finds the application meets the requirements of Chapter 190 Florida statutes to establish Community Development District and recommends approval. I'm available for questions, as is Julie Wisdom. Thank you.
Thank you, sir. Is the applicant here? Good morning.
Good morning.
You've been sworn in?
Yes, I was. My name is Roy Van Wyk. I'm with Hopping Green and Sam's, 119 South Monroe Street, Tallahassee, Florida. I'm here on behalf of the petitioner, Cassidy Properties. All of the underlying uses have been approved for this project already. We're here today just asking you to allow us to establish the community development district around the borders of the existing PD. I have with me staff members who have also been sworn in who can talk to you about the underlying engineering and the management that we have proposed for the community development district. So if you have any questions, I'll be glad to answer them. If not, we would ask that you approve the proposed ordinance.
Thank you, sir. This is a public hearing. Anyone wishes to speak as a proponent? Anyone wishes to speak as an opponent? Motion by Commissioner Murma, second by Commissioner Kemp to approve item E3. Seeing no further discussion, please record your vote.
Motion carried 6-0.
Mr. Moretta.
Thank you, Commissioners. This brings us up to County Attorney item L1, mediated settlement proposal, request for relief proceeding. Mr. Lewis Whitehead is going to give you a brief introduction, followed by Mr. Gormley.
Good morning, Mr. Whitehead.
Thank you, Mr. Chairman. Board members, Lewis Whitehead, County Attorney's Office. Good morning. This item is before you due to the board's denial of proposed major modification to a planned development on January 23rd, 2018. In lieu of immediately filing a petition in circuit court for certiorari relief from the board's denial, the petitioner opted to pursue the request for relief process provided for by state law and the Land Development Code. A landowner is eligible for requests for relief for the process if it believes that a development order unreasonably or unfairly burdens the use of the owner's property. In this instance, the development order is the board's denial of the proposed major modification. The purpose of the request for relief process is to afford landowners and local governments a means to amicably discuss and to resolve land use disputes without the need for litigation. The procedure requires the appointment of a qualified special magistrate. This magistrate's first duty, which gives rise to the agenda item that you have before you today, is to conduct a mediation hearing before the petitioner and the county. The mediation hearing affords the petitioner a forum within which to propose changes to the major modification that address the concerns expressed by the board and citizen opponents in connection with the denial of the proposed modification. The mediation hearing was held on September 23rd, 2018. Counsel for the petitioner participated in the mediation hearing, together with representatives of the County Attorney's Office and Development Services on behalf of the board. The Planning Commission was also represented and participated. Interested citizens were allowed to address the special magistrate without time limitations. Subsequent to extensive discussion and public comment, the mediated settlement proposal before you today was reached by counsel for the petitioner and the county's representatives. The board's approval of the mediated settlement proposal on today will result in the approval of the major modification subject to the revised conditions set forth in the mediated settlement proposal. The board's denial of the mediated settlement proposal on today will advance this matter to the final stage of the request for relief process. At such time, the special magistrate will convene another hearing, and he will determine if the uses remaining and available on the subject property in light of the board's denial of the major modification unreasonably burden the petitioner's use of the subject property. If the magistrate determines that the board's denial of the major modification does not create an unreasonable burden, the request for relief process will conclude. If the magistrate determines that the board's denial imposes an unreasonable burden upon the property, the magistrate, with the owners to consent to proceed, will recommend for the board's approval or denial one or more development alternatives that protect the interests served by the board's denial and afford the petitioner reduced restraints on its use of the property. The request for relief proceeding will then conclude upon the board's acceptance or rejection of the special magistrate's unreasonable burden determination. In sum, both the mediated settlement proposed before you today and any future unreasonable burden determination by the magistrate will require board approval in order for an amended version of this major modification to become effective. Subject to specified time limits, the petitioner remains at liberty to file a petition for certiorari relief, seeking relief from the board's January 23rd, 2018 denial of the proposed major modification. I'll be happy to answer any questions if you have any.
I don't see anyone with any questions, Mr. Whitehead. Thank you very much.
Thank you very much.
Applicant here, Mr. Perkemar. I'm sorry.
Commissioner, I'll give a brief summary of what's recommended in this mediated settlement. The application before the board previously was a major modification to existing plan development that allowed a host of commercial uses on the site. It did not allow and does not currently allow for use of a religious institution. The board heard that in January and based on concerns expressed at the meeting had denied that application. During the request for relief process, the applicant proposed some additional restrictions both on the uses currently allowed in the PD to eliminate some of the more intensive uses, including auditoriums, automobile sales, convenience stores, food catering, and theaters, amongst others, and also offered some voluntary restrictions on the scope and hours of operation of the religious institution. That would limit the use to Sunday service with a maximum of 150 people from 3 p.m. to 8 p.m. Additionally, would permit 4 special services, also limited to 150 people from 3 p.m. to 8 p.m. on days other than Sundays during any given year, and would limit any other religious activities on the site to a maximum of 20 people from the hours of 10 a.m. to 10 a.m. to 9 p.m., and also provides for 2 religious people and office people to be on the site at any given time. With those restrictions, we felt that the use had been sufficiently conditioned to address some of the concerns that had been expressed at the hearing. Additionally, eliminated some of the more intensive uses currently allowed in the plan development, and based on that, recommended approval of the mediated settlement.
Okay. Mr. Perkemar, before you start,
yes.
He has 10 minutes.
I won't need it because Adam did a really good job. Clayton Brickelmeyer, 601 North Ashley Drive. Adam went through all the particulars, so I won't repeat them. I think that this is a much improved proposal. I think that hearing what happened at the original hearing, what we tried to do was make sure that we have limited this as tightly as we can. I think, frankly, I was having discussions with staff during the mediation where they were wanting me to be more realistic about the use of the building. And this is an infill project. It has neighbors. This is what happens when the last few pieces get developed. This property will be developed. It has a bunch right now in the PD. It has a bunch of uses, a lot of which would be significantly worse than a building that's going to be used for 5 hours on Sunday. I'm here for questions. I don't know if you have any, but
I don't see any questions.
yeah, thanks.
Thank you. We'll now move to the comments from the mediation hearing participants. I have a list of those who desire to speak. They have 3 minutes per participant. The first one is Ms. Barbara Merritt.
Good morning, I'm Barbara Merritt. I live at 7212 East Chelsea Street. We are asking you to deny the request for the modification on this piece of property. It's currently zoned, the larger parcel is acreage, and the smaller parcel, the smaller parcel was zoned for residential. The owner of the property attended our neighborhood meeting. He gave us an outline and an overview of what his tentative plans were for the property. He had quite a plan evolving. It goes over years. The applicant has owned this parcel for approximately 14 years and has not kept it up to code. He's been cited several times since 2004 for dumping, overgrowth, improper uses in the zone, inoperable vehicles, and accumulation. He also informed us he will have 2 people living at a temple at all times, or if they're not in the temple, he's going to put a trailer there for them to live in. He said he will conduct well clinic services several times a year, and the parking overflow will have to go to his property to the west side of Orient, to the west side of Orient Road at the corner of Orient and Chelsea. He stated he did not get the zoning. If he did not get the zoning, he would sell the property for $500,000, and he has zoning people lined up to help him. We tried to address the lack of infrastructure, traffic, and safety. The size and scope of the project presented to the community would not be compatible with the existing neighborhood. The property is still on well and septic. We are in an area with major infrastructure deficiencies. Commissioner Miller, how long did it take us to get water and sewer out there? Okay, a long time. We were part of a franchise out there. We are impacted daily by Hard Rock and Florida State Fairgrounds. Our road level on Orient Road is at F level at many times. We are also in the I-4 corridor, and there are also many proposed developments coming down the pike on the drawing board. Part of the problem that the community had with this whole meeting process was we didn't have first, when the property was posted, the property is at a dead-end street next to a park, so people weren't really aware of what was going on because you couldn't see the sign because of the overgrowth, basically. Then, when we came to the meeting in January, we didn't realize that people were not going to be able to speak, that didn't speak at the first meeting. There were petitions. We collected petitions out there. There were 180 people who live, work, and commute in the area. We have a really serious problem with Orient Road. And at the part of Orient Road where they would be using, we're at 2 lanes. We're at the bottleneck.
Thank you, Ms. Merritt.
Okay.
Next is Ms. Linda Wheaton. Good morning.
Good morning. Thank you for hearing us. My name is Linda Whidden. I live on Berkeley Drive in Kings Forest. And my issue with this is, as Barbara was saying, besides the traffic, besides the infrastructures, the problems that we already have, which back in 2013 was announced by Miss, excuse me, Pat, Marciano, that we're at capacity for our infrastructure out there. But I just have to say, if this applicant lives in a deed-restricted area in a gated community, and he doesn't abide by their rules and the restrictions that they have, how do we expect, or you expect, that you give them the permission to build what they're wanting to build in that little area there? We're already boxed in and over there in Kings Forest. We deal with all the traffic that comes off the interstates when there's any kind of wrecks. We're having, there is a projected road construction in 2019 at the corner of MLK and Orient Road that we're going to be dealing with that traffic there. If he can't keep up the property without anything there, how's he going to keep it up with something there? He's told us so many different tales. He doesn't, every time you talk to him, he changes. Mr. Breckelmeyer says he knows of what has been said to us. He can't help it. Well, if he can't help it, what are we going to do? How are you going to do a deed restriction on him in that if he holds 150 people there? We were told at the Planning Commission meeting that if he goes over 100, if there happens to be 200 or more, you can call code enforcement. Well, guess what? Code enforcement doesn't work on a weekend. So you can't do anything about it. Then they said, call the sheriff's office. Well, the sheriff's office already has other things that are more important than us to say, there's people overflowing on Chelsea. Chelsea's a 2-lane road. Orient Road is a 2-lane road. That's our entrances and exits out of Kings Forest, MLK and Orient Road. We deal with enough there already. We're asking you, please do not do this, and especially give an open building, which is what they're wanting, is that if they build the temple, then they want to possibly build later something else like an office, or build later something else there that for whatever else that they may be holding there. We're asking, please do not do this. We're the ones that are having to deal with this already. Please listen to us.
Thank you. Danielle Patterson? Danielle Patterson? Martha Stickley? Martha Stickley? Randy Stickley? Okay. The applicant, you want to rebuttal? You have 5 minutes.
Yeah, thank you. I think you can hear there's some interpersonal conflicts between my client and his neighbors, which I very much hope that he repairs. What I've been trying to stress, and I've had very nice conversations with Ms. Merritt in particular about this project, what I've been trying to stress is that these are the rules that will be put in place, and these are the rules that I expect my client to live up to and that I think he will. This is helping the situation on Orient. There are traffic intense approved uses on this list, some of which we're asking to strike right now just because I think it would be better for that neighborhood, better for the property. It's a better deal. This is, I was just telling them, I've been doing this a long time. This is as restricted as I've ever done any development anywhere, to try to pin it down to 5 hours on a non-peak day. And it's 3 to 8. It's not even, this is not the peak hour. And we've reduced the traffic to this tiny little window. I just think that this is a step toward solving the problems, which, by the way, the neighbors are right. We have owned this property. This is our problem, or the infrastructure problems are our problems. I'm hoping, and I've said this to Ms. Merritt and to my client, that they should be working together to solve these infrastructure problems because they're all in the same boat. This isn't a deal that's under contract. This is a deal that he owns. I think this is a great deal. He intends to go forward with it, and I would ask that you approve it. Thanks.
Okay. Board discussion. I will start off. I don't see anyone in the queue yet, but now I do. I appreciate the applicant's presentation. I appreciate the citizens' presentation. I am very, very familiar with this area, extremely familiar with this area. And they have some serious issues and problems out there, traffic problems. Orient Road is a 2-lane road from Hillsborough going south to I don't remember where. I've been working since I've been here to get that road taken care of. As we all know, we have a $15 billion need in Hillsborough County, and hopefully someday, if everything works out, we will be able to take care of that road. That road feeds the fairgrounds, it feeds Hard Rock. If anything happens on the interstate, it dumps off on the Orient Road. That's a serious problem. This is a quiet, quaint community that's been there a long time, and I just do not believe that this project is conducive to the neighborhood. It's just not conducive to the neighborhood. I understand all the restrictions that have been put on there, and I appreciate that, but I cannot support it. I will not support it. I just cannot see that being there with all the things that you said, all the restrictions put on. there's going to be something else happen later on. So I understand that we could end up down the road somewhere in litigation. We're already in litigation because of other things. It may happen, but I would not support it. Commissioner Kemp, you recognize.
Thank you. Well, I fully expected after the first denial that this would make its way to courts. I voted yes the first time without all the conditions approved. As stated here today, uses allowable at this site include uses that would be much more intense than the proposed use here, including a theater, an auditorium, or an aquarium. The applicant, I think, by this has made a strong effort to make this work by coming to the table and agreeing to what I think are clearly very stringent conditions. I've never seen, I know Mr. Brickemeyer spoke to that, but I've never seen such conditions, actually. I'm sympathetic, as I am all the time, with the traffic and the other issues that people in these communities everywhere have to deal with. But I could see this being much more impactful on the roads. The fact that they do services from 3 to 8 p.m. on Sundays, I think, at a time, I think it's true. It's one of the least times in terms of what we would expect for intense, for peak traffic to interfere with the traffic issues. As I said, the applicants made a strong effort to make this work by coming to the table and agreeing to these conditions. There are remedies, as others have, but I hope that those won't have to be available, that they all can work together to do what they have to do with the issues and uses here. So I'm voting to approve. I urge my fellow commissioners to support this, because I think there could be I think it will definitely, it already has ended up in the courts, will end up in the courts again, and I think that there could be uses that could be much more impactful and much more difficult to deal with than this that are already allowed.
Commissioner Merwin, you recognized.
Thank you, Mr. Chair. Gosh, this item is, you really could go either way, but I think, and I'll just say this for the new members, generally, the district commissioner, we defer to the district commissioners on these because we know our areas, our districts so well. We know the people so well in our districts. And I'm going to defer to Commissioner Miller on this because I do think he has been so involved in that community, from putting water in, buying the franchises, it's just been, and I think I understand what you're saying, Commissioner Kemp, because that does bother me. I mean, they could build a fraternity house there. I mean, God forbid. That would be awful next to Seminole Hard Rock. But I think in this case, I'm just going to defer to Commissioner Miller as the district representative and think he really knows what's best for his area. And I think I'm going to vote. Is there a motion on the floor?
No, there's not.
Okay, so I'll move to, deny the mediated settlement? Is that where we're at? Okay.
Is there a second? I'll move the second. You have Commissioner White.
Commissioner White, you're recognized.
Well, I agree with you, Commissioner Kemp. Commissioner Merman, I wholeheartedly hear what you're saying in the sense that we always, make every attempt to defer to the district commissioner, but, I've certainly had some key issues not go my way in my district for a variety of reasons. Sometimes, it's been pointed out that we're not on sound legal footing. It's whatever the case may be, special circumstances of a citizen or whatever the case may be. I'll say to the two new commissioners that we can really be in a pickle on some of these items because, as much as we would like for some of these to be a legislative process and, to be able to more or better insert our philosophical views. We can't always do that, the way these are structured, and this is a case in point. We're sitting like a judge in a quasi-judicial manner to just look at the facts and determine whether or not the facts are consistent with the laws or rules, whatever they may be, within the land development code or beyond. So, as I see this one, I have to agree with Commissioner Kemp that I just don't think the facts allow us to deny this one. So I won't be in favor of the motion to deny, and depending on how that turns out, if that motion fails, then we would have to put a subsequent motion on the floor to approve it.
Commissioner Merman.
Commissioner Merman, you're recognized.
Yes, I wanted to ask staff about the code violations and what has happened. Has there been a recent code violation activity on the property? Because he did have, that was part of the reason, that came up the last time.
Commissioner, the items that were cited for violations sounded as though they were maintenance issues on the property. If the site were to be redeveloped, the site would need to come through site development, and the condition of the site would be reviewed and be required to be brought up to the code standards. What I heard described was sounded like conditions that can be associated with vacant property where it was not properly maintained and junk or other debris was brought onto the site. I'm not aware of current code enforcement status on the property.
Okay, I mean, I've seen situations where properties being developed aren't kept up also. So I guess if this denial doesn't pass, is there any way we can add a condition that, or is it already in the agreement that they have to keep up, the property?
It's a requirement of the property maintenance code, which is separate from the land development code, but it's a general standard that is enforced through the same mechanism as land development code.
So the residents would have to call code enforcement if there was a problem?
Code enforcement would respond if there was an accumulation of junk, trash, and debris, if there was overgrowth on the property. That's something that they typically do enforce. It's a whole set of regulations that is part of their typical enforcement actions.
Thank you very much.
Commissioner Smith, you're recognized.
Thank you. I never like to hear the argument that if you don't let us do this, we will do something worse in your neighborhood. That always strikes me as a bit bullying, and I think it's not good for relations in the neighborhood. But given that I reviewed this case with staff, and the limits that are being placed on the attendees and the number of services that can be per week, I really think that in this case the traffic impacts are going to be the best you could hope for in that area, even though it has bad problems, but I think this is going to be the best that you could hope for, and so I'll be supporting I won't be supporting the denial. I'll be supporting the item. Thanks.
There's no one else. No, but there's no one else in the queue. But let me say this. If you all think this is the best I could hope for in this passage, I want you to work with me my 18 months I got left to do something to Orient Road. Because I've been fighting for Orient Road for 8 years, going on 9. If this is going to pass today, do something with me, the 18 months I got left on this board, to improve Orient Road so we won't have the conditions we have out there now. Commissioner Overman.
I think part of the issue is that, traffic conditions are always very challenging, but when you have specific times that actually create a bulge, like rush hour, but more intense with say, for example, a church versus a daycare, where you have, maybe delivery all day long. versus, a peak time, like from 3 to 8 on a Sunday, which would be quite fascinating when the fair starts and it's right in that area, as well as when there's events at the fairgrounds on a Sunday evening. It is challenging to find balance, but if we do have transportation-related issues and that's constraining development in that area, then we have to get focused on addressing those issues. In this case, timing matters because we have an applicant that's wanting to do something. But I did find it rather fascinating that the things that were being allowed versus that which was being restricted. There seemed to be some confliction there. If you've got a, industrial land use, you've got possibly trucks and things being delivered in what is a residential area. So there is some conflict in our land code in this particular area that I find a little challenging. But I do understand that the neighborhood is resisting having further development in an area that's not ready for it. And that makes it very difficult to support it.
That's it. That's it. Nobody else.
Oh, okay. Any further discussion? So we have, seeing no further discussion, we have a motion to deny the mediated settlement by Commissioner Merman, seconded by Commissioner Miller. We'll vote.
Motion carried 4-3. Commissioners Kemp, Smith, and White voted no.
Okay. Mr. Moretta.
Commissioners, that brings us to the off-the-agenda item, the commissioner item.
Commissioner Kemp, you recognize.
Thank you. It's a pretty simple item. I'm asking the county attorney to draft a board policy to be considered at a future meeting of this board. The policy would prohibit setting a land use meeting in an election year after the election, but before the new board is sworn in. This happened this year, and I'm concerned that it made a bad impression. I'm not sure whether this has been done in past years. Did a little research, could not find that it had been. But I don't believe it has been, and we should not be doing this again. This prohibition is important with land use decisions because these are quasi-judicial proceedings that affect property rights. Unlike many things that happen at a regular meeting, these decisions can be very difficult, costly, or even impossible to undo. So I'm going to move that the board direct the county attorney's office to draft changes to board policies to provide that land use meetings shall not occur during a lame duck session of the county commission in an election year.
That's a motion by Commissioner Kemp. Is there a second?
Second.
Second by Commissioner Smith. Commissioner White, you recognize.
I'll just ask county staff, this would have to be in the land development code, is that correct?
Actually, this change could be made within the board policies, the rules of scheduling of meetings. So it could be accomplished with the approval of a resolution.
So just a couple questions for Commissioner Kemp. Would you envision this being drafted in such a way that we would have a November land use meeting if there are no changes to the board in an election year? I mean, that would probably be difficult for staff.
You
though,
couldn't
to have it
speculate
planned.
that, so that's why I would just do an all-out bar, because you just can't speculate about that, and these meetings are done with great notice.
Right. What about routine land use decisions, that would ordinarily be on a consent agenda? You're just basically proposing that we just don't have a November land use meeting in election years.
Well, or yes, I guess we could have it later, after the new commission's sworn in, if that can be arranged that way, but yeah, that's what I'm proposing.
That almost always gets into Thanksgiving and the meeting free period, so I would imagine we would just not have a land use meeting in November.
Although we
election
certainly
year,
do
so-
have a very light agenda right now.
Yeah. So,
Yeah, that was my intent. I did that. So.
yeah. So,
Thank you.
I mean, is that where staff thinks they would arrive with this, or?
Commissioners, we would have to look at the scheduling and whether it would be feasible to have a land use meeting in November. It would certainly, during an election year, it would certainly push the scheduling of the land use meeting further out than the typical second Tuesday of the month. We would have to look at what dates were available.
If we're going to do this, I would be in favor. I mean, it's only every 2 years to just say in those years to just not do one in November. Yeah. So, okay, I'll support the motion on the floor because staff's going to bring something back for us to then discuss and debate,
Exactly.
take a vote on. Okay.
Commissioner Hagan, you recognize.
Thank you, Mr. Chair. I'm not going to support the motion. I do not understand the rationale behind the request. Candidly, it's symbolic at best. The reality is that it will not have the desired effect or impact on the timing of land use applications or on land use or lame duck boards. And here's why. The applicant determines when their item is heard by the BOCC based on when the application is initially filed. If they believe the existing board will be more amenable to approve their request, they'll simply file it a couple weeks ahead of time. On the flip side, if they feel that a new board will be more inclined to support their application, they'll hold off for a few weeks. So I'm not going to support the motion, and I also feel that if the board is inclined to consider this request, it should also include regular BOCC meetings. I mean, if the board feels this is good policy to neuter lame use or lame duck boards, then have it apply to all of our meetings. I mean, I don't understand the rationale. It's not going to have the desired impact. It's purely symbolism.
Commissioner Overman, you recognize.
As a new board member, getting your arms around land use as a brand-new commissioner is a bit overwhelming. But I will suggest that we're talking about probably 14 days. You know, whether we can do it at the end of November, after or before, you know, and be able to schedule it well before the election, if that's the case. I don't see it as being an overwhelmingly unable to do agenda. You know, lame duck votes are always fascinating in how they happen. And to your point, if we're going to do it for land use, we might want to do it for the overall BOCC meetings. But I'll support the effort.
Commissioner Merman, you recognize.
Thank you, Mr. Chair. I'm going to wait till the language comes back to really opine on this. I want to see the details. I understand what you're saying, Commissioner Hagan. My first reaction when I saw this was not to not support it, but that I feel like we're politicizing our process in some way, that you know, we're saying what can't be in front of us and what can be in front of us during election years. And I guess I feel like those type of things are not up to us. We don't set the agendas. The people that are in the process have filed applications, staff certainly, you know, schedules things appropriately. So I guess I'm going to wait till it comes back. I'll let this move forward, but I think it's worthy of more discussion as we go forward, because I don't want the public to think that we're picking and choosing items to come before us during election years. That would not, I think in the public eye, that would not set very well.
Commissioner Smith, you recognize.
Thank you. There certainly is a public perception that some important land use items and other decisions are made during this lame duck session with commissioners that the public has voted out. And yet they're making these decisions that impact neighborhoods forever, for generations to come. And it may be coincidental, but the lame duck session this year was 2 big giant binders full of items, and then this session is very, very light, the one right after. So there's this perception that the developers aim at the commissioners they know, so I think it's certainly worth exploring and looking into to be above reproach on the decisions of the boards moving forward. And so I'll support it.
Mr. Hagan, you recognize?
Yeah, quickly, I'll just say I couldn't agree more with Commissioner Smith, and that's essentially what I said. The applicants, they know the system. All they're going to do is file a couple weeks earlier and be heard in October. It's not going to have the desired impact or effect. That's the reality, whether you want to accept it or not, but that is the reality.
Okay. I'm going to say this. When I originally saw this, I was going to vote against it. I'm going to vote yes to carry it forth because I'd like to see the language. You did make a motion to have staff draft something, am I correct? Understand this. You are a commissioner if you're lame duck until the day you leave office, okay? You have a responsibility. You took an oath. Regardless if you're lame duck or not, you have a responsibility and a job to do. So if we have land use meetings or regular board meetings, you have a lame duck commissioner or commissioner sitting there, they still have to push that red or green button and make a decision. You just can't say you're lame duck, so in November you're going to take off and that's it. No, it doesn't work that way. That's not the law. It's just like Congress or just like Congress. You have some lame duck members there now, but they're Congress people and senators until January. So to sit here and say, because you're lame duck, we're not going to do the work of the citizens, you're violating the oath that you took. You are. But I'm going to vote to take this forth, but if it comes back and I don't like the language or where it's going, I'll be voting no. But today I'm going to vote yes to carry it forward. Okay? So I have a motion by Commissioner Merman. I'm sorry. A motion by Commissioner Kemp, second by Commissioner Smith. Is there further discussion? Please record your vote.
Motion carried 6-1. Commissioner Hagan voted no.
Mr. Beretta, anything to come forth?
That concludes the land use agenda. We now have the Planning Commission agenda.
Land use meeting is adjourned. We're now moving to the Planning Commission's comprehensive plan amendments. Garcia.
Good morning, Mr. Chairman. Tony Garcia, Planning Commission staff. We have several amendments for you this morning that we will be providing brief presentations on in anticipation of adoption hearings, which will be held in mid-January before this board. The first item before you actually will be heard, though, this coming Thursday. This is the only item that you'll be hearing today that will be going forward this Thursday for adoption, which is Plan Amendment 1816. All the other amendments before you today will be heard in January.
Good morning.
Good morning, Commissioners. Unica Mills, Planning Commission staff. I'm here to present to you Future Land Use Map Amendment HCCPA 1816. This is a properly initiated plan amendment, small in scale at approximately 9.15 acres. The subject property is located within the vicinity of Martin Luther King Jr. Boulevard and North 69th Street. The property is also located within the urban service area, as well as the East Lake Orient Community Planning Area. The request before you this morning is to change the future land use designation from Research Corporate Park to Light Industrial Planned. Here is an aerial of the site. The area is a mixture of uses. Along Chelsea Street, which is to the north, we have a pocket of residential which is west of the site here. The site currently, this portion of the site is vacant. There is a church on this portion of the site. This portion is also vacant. As well, other uses include some light industrial here. There's also further west of the site, light industrial uses. Excuse me, let's go back. The red dotted line you see here is the portion, north of that is the portion of the site that is not within this plan amendment. So south of that red portion line is what's being requested to change to light industrial planned. This is just another aerial of the area. Again, that pocket of single-family residential. We have light industrial uses here, a mobile home park south of the site, and other light industrial uses along MLK. Currently, the future land use designation of the site is Research Corporate Park. And again, the request before you this morning is to change the future land use designation to light industrial planned. Impacts, if approved. Currently, a residential potential of up to 274 units could be built, or for non-residential entitlements, over 398,000 could potentially be built. The proposed, if approved, residential development could not be built on the site. As well, there will be a decrease in non-residential entitlements if approved. There's no action required on your part. I'll be back before you
Thursday.
on the 17th, excuse me, that's incorrect. I'll be back before you, I'll be back before you on the 13th, as this says, a few days for you all to make a final decision on this for a public hearing.
Okay, I see no questions. Thank you very much. Mr. Garcia?
Thank you, Mr. Chairman. The next item up before you is a Hillsborough County Comprehensive Plan Amendment 1818, which is on Bloomingdale Avenue and Gorentoe Lake Road. Ms. Krista Kelly.
Good morning, Krista Kelly, Planning Commission staff. Today I'm presenting Comprehensive Plan Amendment 1818, Bloomingdale Avenue and Gorentoe Lake Road. This is a privately initiated amendment on 21.3 acres. The site fronts on Bloomingdale Avenue and is approximately a quarter mile east of Gorentoe Lake Road. The site is in the urban service area and within the boundary of the Brandon Community Plan. This area shows the site outlined in pink. As you can see, it's sparsely developed. However, the area is transitioning to a quite suburban, high-density area with some commercial intensive uses. Directly to the south, there's outdoor storage. It's an upholstery business. To the east, mini storage has been approved, and on the next aerial, I can show you a more current view of that. To the west, on the west side of Gorentoe Lake, is a super Target. And north of the Target are villas, and south of Bloomingdale and south of the site are additional villas. This is the more current site provided by the applicant, and you can see to the east, this is an open storage that has recently opened. The site is currently approved or adopted with the suburban mixed-use 6 land use category, as is the surrounding area. South of the site, the villas that I indicated earlier are designated residential 16. To the west, the area is community mixed use, and to the south and west is community mixed use and urban mixed use. The bright yellow is residential 6. The applicant is proposing a change to residential 16, similar to the villas to the south. Currently, the site allows 127 dwelling units, which would increase to 314 units. The square footage for non-residential uses would remain the same at 175,000 square feet. That concludes my presentation. I'm happy to answer any questions.
Mr. White, you recognize.
Thank you. I'll just say at a high level that I like the proposal here before us when we talk about holding the line with respect to residential suburban sprawl. This is really a textbook case of how we accomplish infill development. And I like the overall vision for land use in this corridor. I'll just say 3 things just to consider moving forward. Some things that I'd like to see is, one, early engagement with those neighbors on suburban scale lots to the north. I would think any concerns there would be remedied at a rezoning phase of the process, but it would certainly be good to engage those neighbors early on and begin to have a dialogue. I've heard that there may be a desire to have a bus stop along Bloomingdale Avenue with this site, so I'd like to see those conversations continue as well. And to also think about future connectivity to Gorentoe Lake Road. I know that's not a possibility out of the gates because of landowners to the west holding parcels independently of the site that we see before us. But I'd like for, again, and this would likely arise at the rezoning phase of the process, but I'd like to see us think about connectivity over to Gornto Lake Road. But at a high level, very supportive and anxious to see this move forward.
Commissioner Merman, you're recognized.
Thank you. Couldn't agree more, Commissioner White. I think this project offers so much opportunity as the kind of projects we're trying to develop here, those live, work, and play, really dense areas, because I know I go to Target there, go to Home Depot, Steak and Shake. That whole area is just filled with residents, and I just hope that more commercial development will happen in that area to even bring it further along. But I think it's got huge opportunities for transit, and couldn't support this one anymore. I think it's got a good potential.
Okay. No more questions. Thank you very much.
Thank you.
Mr. Garcia.
Thank you, Mr. Chairman. Next item is Hillsborough County Comprehensive Plan Amendment 1819. This is on 33rd Street Southeast, south of College Avenue. Ms. Mills, once again.
Good morning again, Commissioners. Unica Mills, Planning Commission staff. I'm here to present to you Future Land Use Map Amendment HCCPA 1819. This is a privately initiated plan amendment on approximately 5 acres, small in scale, located within the vicinity of 33rd Street Southeast, south of College Avenue. The property is located within the urban service area as well as the Ruskin Community Planning Area, and the applicant is requesting a future land use designation change from suburban mixed use 6 to community mixed use 12. Here's an aerial of the site as represented by the yellow star. Here's the site here. Within the area, the development pattern is we have Ruskin Inn, which is west of the site. We have a convenience store further west of the site. Across College Avenue, we have a strip center here. Along 33rd Street Southeast is a pocket of residential here. Again, the current future land use designation of the site is suburban mixed use 6. And the request before you today is to change the future land use designation to community mixed use 12. Currently, up to 30 units could be built on the site. Non-residential entitlements are at approximately 54,000 square feet. Potential for the site, if approved, up to 60 units could be built, or over 109,000 square feet of non-residential entitlements. So basically, the residential as well as non-residential entitlements would increase for the site. I'm happy to answer any questions if you have any, but that concludes my presentation.
Okay, I see no questions. Thank you very much. Mr. Garcia.
Thank you, Mr. Chairman. Next is Hillsborough County Comprehensive Plan Amendment 1820. This is a future land use map
I'm sorry.
amendment on Loose Lake, Fern, and Sun Lake.
I'm sorry before.
Oh, I'm sorry.
Commissioner Smith is recognized.
I'm sorry, I didn't push my button fast enough. That is, the applicant is Cracker Barrel in that case of 1819?
1819.
Yes, ma'am.
Yeah, and I can tell you, I live in that area and worked on the Ruskin Community Plan and worked with the Sun City community as well, right across the interstate from there. That would be one eagerly awaited Cracker Barrel. So I would be very happy to support that.
I'm not sure if that's, I mean, that'll be settled at the rezoning stage, of course, what we're going to get. Okay.
Right.
All right, 1820.
Krista Kelly, Planning Commission staff. I'm presenting Comprehensive Plan Amendment 1820, Lutz Lake Fern Road and Sun Lake Boulevard. Again, this is a privately initiated map amendment on 9.4 acres. The site fronts on Lutz Lake Fern Road to the north and Sun Lake Boulevard to the south. Again, it's in the urban service area and within the boundary of the Lutz Community Planning Area. This is an aerial of the site. As you can see, it's there was one structure on the site. It's largely undeveloped, as is the area surrounding it. To the north, there's more suburban-scale residential development. The site's currently designated Residential 1, as is the majority of the area to the west. The applicant is requesting a change to Residential 6. Currently, 9 units can be developed on site. It would increase to 56 units if the amendment were approved. The square footage would increase from 30,000 square feet to 102,000 square feet. And that was a brief description, but I'm happy to answer any questions.
I see no questions. Thank you.
Thank you.
Mr. Garcia.
Not on. We now have a Hillsborough County Comprehensive Plan Amendment 1821, which is, there are two amendments here. There's a companion amendment, there's a text amendment, which is 21, and there's a map amendment, which is 22. This involves the creation, 21 involves the creation of a new land use category, the Innovation Corridor Mixed Use 35.
So
Mr. Pedro
We're
Parra.
going to hear both at the same time, 21 and 22?
He'll go into one, and then he'll go into the second one, then you can have discussion.
Pedro Parra, Planning Commission staff. Comprehensive Plan Amendment 1821 is a text amendment. It is proposed to provide a new future land use category entitled Innovation Corridor Mixed Use 35. The plan category descriptions in the future land use element are broken into 3 sections: residential gross density, typical uses, maximum floor area ratio, and specific intent. Let's all walk through that in terms of this new plan category. The plan category is patterned after an existing residential mixed-use 35 land use category. So what I handed out to you today is the proposed with a strike-through and colored text showing new text, and text is being changed from the regional mixed-use 35. I've handed it out because in your packet, you'll see in yellow a portion that was added after the mail-out date of the packet itself. So under the residential gross density, this plan category would allow up to a maximum of 35 dwelling units per gross acre or a floor area ratio of 2. The residential may be determined either by the density or by the floor area ratio, whichever is more beneficial, which is different than the existing residential, the existing categories in the county's comprehensive plan. Density bonuses and credits are allowed, and there's no minimum lot size. Typical uses. The typical uses are residential, regional scale, retail, commercial, office, and business parks. Added with this new category are biomedical research, institutional hospitals, and in the existing categories include research corporate park uses, light industrial, multi-purpose, and clustered residential and or mixed-use projects. Again, this category will be held to be generally consistent with the policies of Objective 19, except for the acreage thresholds. And Objective 19 talks to all development in the mixed-use categories being integrated and interconnected with one another. The maximum floor area ratio or square footage. Again, a FAR of 2, floor area ratio of 2, intensity is allowed for any single or mixed use. 35 dwelling units per gross acre are allowed, and again, the residential may be determined either by density or the floor area ratio, whichever is more beneficial. The specific intent of the category. This category is intended to be applied along segments of major corridors relatively proximate to the University of South Florida. That area is a regional activity center in the plan. There are 2 others, West Shore and the downtown. The specific intent is it shall form a regional activity center incorporating internal roadway systems, and it shall reflect elements of mixed-use design. And included in your packet under the mixed-use design are components that talk to pedestrian, bicycle, and roadway connectivity, horizontal and vertical integration of uses, pedestrian-oriented walkability, and roadway corridor sensitivity and presence. a continuation of the specific intent of the categories is to foster opportunities for live, work, and play developments. Retail, commercial use clustered at arterial and collector intersections or integrated as part of a mixed-use campus, mall, or a combination thereof. It should be surrounded by complementary plan categories. And again, this area is an area that does contain some of the higher densities allowed in the county and the mixed-use categories. And it should be located proximate to high-level transit lines. Also included in your packet is a table. That table is a table of allowable density and intensity increases for the provision of housing. As I said, the text itself includes the provision that housing credits may be allowed, and so it speaks to, in this category, a housing density bonus or increase from 35 to 50. And that is my presentation. If there's any questions, I'll try and answer them or bring them back to you.
Yes, Commissioner White, you recognize.
Did I hear you state that the, quote, University of South Florida area is defined elsewhere in the comprehensive plan?
University of South Florida is identified as one of the regional activity centers in the plan.
Within the plan?
Yes.
But is the University of South Florida area defined as some specific area elsewhere within the plan?
No, it is not.
I would like for staff to consider adding a bit more specificity to this highlighted paragraph as it comes back to the board. For example, referencing the University of South Florida main campus area so that there's no question that we're not including any satellite facilities or anything like that.
It's a point well taken, Commissioner, as we actually had that request made by one of our, this was presented to our Planning Commission last night, so that same exact request was made to specify University of South Florida main campus.
Got it.
So,
And I would also consider adding a maximum distance from the USF main campus that this can be applied, to add a bit more specificity.
noted.
All right.
Mr. Garcia.
Mr. Parra, once again, this is going to be the companion amendment, Comprehensive Plan Amendment 22.
1822. Okay.
Comprehensive Plan Amendment 1822 is the future land use amendment on the north side of East Fowler, east of North 19th Street. It is a change from the existing residential 20, urban mixed use 20, and office commercial 20 to this new category that we just went through, the Innovation Corridor mixed use 35. It is a privately initiated plan amendment. It's approximately 83 acres. It is essentially the University Mall site. It is in the urban service area, and it is in the University Area Community Plan boundary. What you see in front of you is a larger scale area of the surrounding areas. So if we look at the site itself, this is Fowler Avenue. We have Bruce B. Downs and 30th Street. We have Fletcher Avenue. We have 275, Nebraska, and the CSX Railroad. This, if we start at the bottom, the type of development that is currently in place along the Fowler Avenue includes commercial, retail, and office space. That is along the corridor. It also extends, if we start moving to the east, the University Square development here. If we then move south of the site into the city limit, the city limits runs along Fowler Avenue, and then it goes north along Bruce B. Downs to Fletcher Avenue. So in the city, within the city limits, there is single-family Copeland Park, single-family. Going across the intersection of 30th Street and Bruce B. Downs is an industrial development, and then the university itself, the Research Corporate Park, and again, the medical hub, the Moffitt and South Florida is on the north side of Fletcher Avenue. We have the Veterans Hospital on the west side. And then surrounding the site, if you get in a little closer, there's multifamily, single-family, multifamily. I would add that in the last couple of years, we've added there have been two plan amendments that have replaced the categories with the residential mixed-use 35, and that had occurred at about this location, and also it occurred just north of the University Square development. Going around the area that you see here, going south of Fletcher Avenue, and on the west side of the mall is mostly residential 20, and then we go back down to those adjacent to East Fowler Avenue, and those are the commercial retail office space developments. Here is a closer in version. Again, here is University Square, commercial uses, commercial along Fowler on both sides. This is the city limit and county boundary, and then again it goes through and up north Bruce B. Downs. Multifamily, single family, multifamily, and then if we start looking out on the east side, it is multifamily, and those are residential 20 categories. The single family is residential 6, and the residential density south in the city limits is also residential 20 on the west side, and then there is some residential 6 on the east side. So the adopted future land use categories currently in place. On the site itself, the dark brown is residential 20, and the urban mixed use 20 is here. Within the county's corporate limits, the red is office commercial 20, the yellow is residential 6, and the purple is a regional mixed use that I talked to you that are recent additions to the future land use element. And then in the city itself, we have the community mixed use 35, both on the north side and south side of Fowler Avenue. We have some public uses on the university. We have the suburban mixed use category, and here in the corner we have industrial. Again, the proposal itself for the site would include everything but you see here, which is a cutout. So the urban mixed use 20 would remain on this site. The rest would change to the innovation corridor mixed use 35. The impacts in terms of maximum potential intensity and density, the existing plan categories would allow up to approximately 1,600 units. Under the potential proposed category, it would go up to about 2,900 units. The existing intensity would be about 3 million square feet, and it would go to approximately 7 million square feet. And that is the end of my presentation.
Commissioner Kemp, you recognized.
I'd just like to say I'm very pleased to see this coming forward. And, you know, for decades, you know, have seen that area certainly it would be ripe for redevelopment. The, you know, retail now, the malls are declining and not, people aren't going to them as much, but to think that it's always been, I guess by having more students living on campus, but, you know, in most communities that you go to, the university areas are thriving places of walkability and, you know, have all kinds of potential. And I just see this as starting to realize the potential. And if you could, just because I realized after I talked about this, a lot of times people didn't know this, but if we could go back just for a minute to the map and you could kind of just show where the CSX tracks go from Fowler Avenue right there along the south to Fowler and 30th, and you can look right across, because I had someone not believing that those tracks existed, someone who I've been asked many times, but if you can just show with your finger or the pointer.
The pointer is following the CXS.
Yes, how about across Fowler? Yeah, just south of Fowler there, the way they go. And I know you can just stand there at Fowler and 30th and look across at the campus, and that is exactly where the CSX tracks go. Can you just along Fowler to the south is where they, kind of where that road alignment is there, or whatever that is. I'm not sure if that is the CSX alignment, but it is so, we have such great potential for great walkability, great transit, great community, great everything, pedestrian trails. I know Mark Sharp has been very excited, with regards to the potential for pedestrian trails, for all kinds of things there. So I see this as very exciting. I just wanted to comment to that extent.
Okay, thank you. I see no one else.
Thank you.
Mr. Garcia.
Thank you, Mr. Chairman. The last item before you is Hillsborough County Comprehensive Plan Amendment 1823. This was initiated at the request of this body, Commissioner Merman specifically. Thank you. This is a coastal management. This is going to be changes to coastal management element and the conservation aquifer recharge element and the definitions section and also the future land use element. This is something that has been a collaborative effort, just to let you all know, between our staff and the county staff, their planning staff, and their legal department, in addition to the Port of Tampa and EPC. So with that, I'm going to have Ms. Mills go ahead and talk to you about the proposed text change.
Good morning, Commissioners. Shanika Mills, Planning Commission staff. I'm here to present to you HC CPA 1823, which is a future land use text amendment, as well as conservation aquifer recharge text amendment. There'll also be changes to the coastal management element. Again, as Tony mentioned, this was by the direction of the Board of County Commissioners at its June 12th land use meeting, and the Planning Commission was directed to create new policy to prohibit the development of submerged lands. So there were a series of meetings held between Planning Commission staff, county staff, EPC, as well as the Port Authority to craft a language that you'll see in your packets. New policy will be added to the future land use element, which speaks to land use designations, any new land use designation, and new changes to existing land use designations that are on surface water are to be limited to the natural preservation land use classification. Also, new language will be added to the coastal management element, which will speak to the filling of surface waters can only take place for the purpose of incidental fill and governmental projects that are necessary to promote public health and safety. New language will also be added to the conservation aquifer recharge element. The language speaks to the protection of conservation and surface waters. And finally, there will be new language added in the definition section of the comprehensive plan for the meanings of incidental fill and surface waters. And again, all of the policy language is provided within your packets. That concludes my presentation. I'll be back before you on January the 17th for a public hearing.
Thank you. Commissioner Merman, you recognize.
Thank you. Very briefly, I want to thank you for your presentation. I want to thank staff. This has been something that we've worked hard the last couple months to get everybody to agree on what this policy would be, but it is so important. As you all know, I'm the Coastal Commissioner, and we have to remain very diligent to make sure that the submerged lands are not used for development, and as was tried over in Rocky Point. So I'm on it and want to make sure but thank you. It looks like a good policy. Thank you.
Commissioner Kemp, you recognize.
Thank you. Commissioner Merman, first, I'd like to thank you so much for bringing this forward. I know you've been a big champion of it, and I know how important it is in light of sea level rise, climate change, habitat preservation, the need to build in strong protections. I'm generally supportive of all of this. I like that the public health and safety and welfare is in there. I've been looking over this closely vis-a-vis the what the city put forward, what we've put forward here, and I have a very small tweak, I think, to the proposed language to make it clearer. And I'll just, if I could, just put this up on the Elmo, and maybe we could just pass it, or here, thank you. Just so everyone knows. It's the very smallest of the drafting changes. It really doesn't eliminate anything. It just changes the, so you have that piece, and that is, right now, you could look at your proposed language. And what it does is it says, here's the current proposed language. This is what I'm submitting. But right now it says governmental projects that are necessary to promote public health, safety, or general welfare, including activities that facilitate the continued use of existing channels, activities associated with appropriate water-dependent uses, water-related uses, and uses pursuant to the Port Master Plan, and activities that correct environmental problems. The only way that I change it is I take out of the last line and uses pursuant to the Port Master Plan and move it up to right after governmental projects, comma, including but not limited to uses pursuant to the Port Master Plan, comma, that are necessary to promote. So move that little clause from the last sentence up there to the first, just to make it a little more clear in drafting.
So are you proposing that to be an amendment to this?
If I need to propose it to be an amendment right now?
Not now, because we're not voting on it. So
Right.
you have to bring it back on when we'll be hearing this?
January 17th.
January 17th. Okay. Commissioner White, you recognize?
Well,
I'm sorry. Go ahead, Commissioner White. I think I dropped. You're next, I'm sorry. It should be Commissioner Smith, I'm sorry.
Okay. Commissioner Smith, you want to go first? You were the
I dropped somebody too quick, so go ahead,
Okay.
Commissioner White.
Well, I guess an alternative way to approach this, I guess first I want to ask Commissioner Merman, as the champion of this, how she feels about that change to the language.
Want to ask for that in January?
Yeah, I think, in my personal opinion, the Port Master Plan is still evolving. And I have been very concerned about an area that has been proposed for development that may include submerged lands. That's in the Port Master Plan. So I think we just have to wait and see.
Mr. Chairman, if I may make a suggestion, it might be much easier on the board to just have staff bring both options, the original option
Right.
and this option, and we choose one. One gets voted up, one gets voted down.
Right. I think so.
Okay.
Good option.
Commissioner Smith, I apologize for that. You recognize.
No problem. I had the sense he was going to address what just happened, so it made more sense to flow that way, actually. I just have a question maybe for, well, maybe, we'll see. My question is, on Section 2, governmental projects that are necessary to promote public health, safety, or general welfare, who decides that? Is it the county commission who decides whether a project is necessary to promote the public interest? Or could the Port Authority be deciding, or some other body?
Oversight Committee.
Good morning, Commissioners. Sean College, Planning Commission staff. Been working on this with county staff. In this particular policy, this is the second policy, which is dealing with specifically with regard to fill. And this is the county's comprehensive plan. So the county, the Board of County Commissioners, the ultimate arbitrator of the interpretation of their policies. So, so in as much as a project would come before you, you would interpret this policy and make this decision. However, that would be in a case where projects do come before you, and in some cases they don't come before you, depending upon what the port or other activities that are being done.
So, so there's cases where, let's see, where the port could decide to fill submerged lands based on their own determination that it's in the public interest?
No.
the way the process works right now with regard to a port has a sovereign submerged lands permit,
Right.
which they are the permitting body, as well as in certain cases where they're doing development, they are also the applicant. In practice, their understanding is that they are required for these permits, for these activities to be consistent with a local government comprehensive plan by law. That's their interpretation of state law. The Planning Commission is the local planning agency pursuant to state law, which manages and maintains the comprehensive plans. And in practice, for standard work permits, they have been asking the Planning Commission for an interpretation of consistency. So,
Okay.
and the Planning Commission has been taking up, examining port permits and making a recommendation to the port as to whether these permits are consistent or not with the comprehensive plan. And so in this case, that would probably be what might happen here with regard to a standard work permit. That does not, I don't think, preclude an applicant from going a second step and coming to the Board of County Commissioners and requesting their interpretation of their own comprehensive plan. Just in practice, what I've seen since I've been working is that the port has been stopping with the recommendation from the Planning Commission. What I've seen in my years of working here is in some very rare cases, there have been port permits where initially are submitted that the Planning Commission staff has found were not consistent. And when that occurs, we've been working with the applicant, and they've typically brought these projects into consistency prior to final action by the Planning Commission.
So it could be the Planning Commission determining that it's in the public interest or not.
The Planning Commission, as with everything the Planning Commission does, except for Tampa's redistricting, it's a recommendation. We make a recommendation.
So then
to
it comes to us.
Well, in practice, the port has been accepting that recommendation and going forward with their permitting based on the Planning Commission's recommendation. What I'm saying is, if an applicant did not agree with the Planning Commission's recommendation and they wanted a further opinion, they could seek that opinion from the Board of County Commissioners, because it's their comprehensive plan, and the Planning Commission is just making a recommendation.
Okay. And I have one more question. Historically, there have been some cases of the port filling submerged lands for industrial port-related business that then became residential, like Seaton Island turning into Harbor Island. So once they were granted permission to fill submerged lands for a necessary public purpose, how can we prevent those from later on converting to residential?
I think the best way to do that is by virtue of what land use designation and zoning that you give that property.
And it would always have N for natural, well, no.
Natural preservation would preclude virtually any kind of development. You could do industrial, something related to port uses that are more commercial. Those are options for you.
And so then it would always have to come back for a hearing in order to convert.
Correct, to the Board of County Commissioners for ultimate decision on the change in land use, correct.
Thank you.
Okay, members, those questions by Commissioner Smith were good because being a new commissioner, she needed to ask those questions. Now, before we get into a debate on any of these, remember, we're not voting on these today. We will see them again January 17th. And the last one, 2018-23, Commissioner White has already asked for a comparison for both of them to get back together. Am I correct? So there's no need of debating these to death today because you're going to see them again in January 17th. Okay, so let's just be ever mindful of that. You're not taking a vote on these today. So if you want to debate or bring forth amendments, that's the time to bring it forth. Commissioner Kemp, you're recognized.
Thank you. I was actually going to ask the same questions that Commissioner Smith, but I just wanted one clarification, if you would, because I'm not sure I totally understood. It's probably just me. But in terms of what you said, you bring it to the Planning Commission. It sounds like if the Planning Commission finds it inconsistent, then it doesn't move forward from there. You take that, if it's an inconsistent, you take it as a final opinion until you can get one that at least the Planning Commission moves forward. And then if the Planning Commission does, then it comes to the board, just to clarify.
The port it's their understanding that they cannot issue a permit that is inconsistent with a local government comprehensive plan. So they do take to heart when the recommendation from the Planning Commission, if it would be that it would be inconsistent. At that point, in practice, what has happened, and it's very rare, but the applicant, and typically it's a private applicant, will then revise the plans of the project to bring it into consistency so that they can get a recommendation of consistency from the Planning Commission. That's what's happened in practice.
And then it always comes to the BOCC for
No.
final?
No. In practice, the port has accepted the recommendation of the Planning Commission, and I don't want to speak for them, but I believe they think they're on sound legal footing with a recommendation from the local planning agency as to consistency. Now, that doesn't preclude a private applicant or the port from going above and beyond and saying, well, I understand what the Planning Commission has recommended, but I'd like to ask the BOCC to issue their opinion. But in practice, that has not happened.
But there's no requirement then, so I just think I don't know where this goes, but I think it should have to come back here in every case for every approval. I can't understand why it would not, like everything else under county jurisdiction. So I'm just wondering, in terms of moving forward, how that happens.
I don't want to speak for the port, but my understanding from working with them is actually they don't have a requirement to request, they don't have a requirement to get the opinion from the Planning Commission. There's no requirement for them to do that or to get it from the BOCC. They just do it because they want to be on sound footing to know that it's consistent. They just have a requirement that their permits are consistent, but they don't have a requirement that they seek that opinion. They just do it as a courtesy, as a way to put them on sound footing. So I'm not sure that you could require them to come before you, but that might be something for staff to investigate.
Commissioner Overman, you recognize.
Again, being a new person, I'm trying to make sure I'm not excluding something that is already in place. So we have an island out in the middle of the bay that apparently is going to be used for commercial purposes. If they needed to apply for something more than infill to support their venture, would this prohibit that from happening? I mean, it's already there, it's already in place. But if there's any changes to this, or their need to, would it be this would be impacted? Or this particular planning change would impact them?
Yeah, I don't believe what we're considering here would impact the issue of that island because, as I understand it, they're not proposing any fill on that island. That island is already existing, it's already land. It's land that does not have, as I understand it, zoning or land use, so that's the issue with regard to that island. Really what we're dealing with here is water or activities or construction in water that is not yet land, and how do we deal with that?
Okay, thank you very much.
Ms. Garcia, I see no further business coming for us today.
That concludes our workshop, sir.
Okay, we adjourn.